Hello. I see Osbrook is already in the chat making problems. I know a lot of people are waiting. So I was just talking to Cara backstage. So as you can see, we're doing some nerdcore tonight, as I like to call it. I'm sure it's probably already taken, but if not, TM, TM, TM. Um, so we're going to be talking about direct appeal versus what is post-conviction relief. Probably won't dabble into habeas, but we've got an excellent demonstrative that Miss Cara Wieneke is going to be walking us through. I know a lot of people have a lot of questions about what's going on with Rick Allen. Why is it taking so long? Blah, blah, blah. And so I am going to just bring Miss Cara on up. And hello, everybody. Hi.
Hey,
There she
here
is.
I am.
Hello. Thanks so much for and we have our first. Oh, I don't know if you heard it. We had our first sirens of the evening.
Does this go on just all day and night?
Oh no,
Oh,
it's around the corner is a fire station. So every once in a while, it's like they get a flurry of calls. But no, so no, it doesn't. Otherwise, I go bananas. I would go nuts. So how are you? Thanks for joining this evening.
I'm good. I'm good. I have a traveling oral argument next week, so I'm in prep mode.
What is so? Wait a minute. A
So,
traveling
so
or
the Court of Appeals likes to do this Appeals on Wheels program where they will travel around the state and they'll do oral arguments at like high schools and things. And so this one's at a high school up in sort of northeastern Indiana next week. So they like to go up. We do it in the oral argument in front of the students, and the students can ask questions, not about the case, of course.
Right.
And they'll talk to the judges, and then we have a lunch afterwards with some of the students. So it's a
Oh,
lot of fun.
that's cool. I think that hopefully they ask you a lot of questions about what does due process of law mean? What's innocent until proved guilty mean?
You
What's
know,
burden?
they always ask the judges questions, and they're always different. It's kind of crazy. I don't ever hear the same question twice. So,
Yeah.
and
Yeah.
I think they get the briefs beforehand, and the students get to
Oh,
read
nice.
them. Yeah. So,
Man.
yeah,
That's
it'll be
now
fun.
that's nerdcore. Exactly.
It is. It is. It's a lot of fun.
I love that. So what's the case in brief about? Is it
The
just
case is my client was a semi truck driver, and he drove, according to the state, there's like these regulations. You can only drive so many hours before
right?
taking breaks and all of that. He drove more hours than he was permitted to. And then during one day, he got into an accident and unfortunately killed two older people.
Mhm.
And so it's a reckless homicide case. And his attorney asked if the jury could be instructed on the difference between recklessness and negligence. And the court said no. And so that's the issue.
Oh,
Because
yeah.
it's not, there's no criminal negligence in Indiana, really. And so it's got to be at least reckless. And if you can find somebody who can really tell the difference between reckless and negligence without reading case law,
Right.
good luck. Yeah.
And they were denied an instruction on that.
Yep. So the jury just went forward, with what they had. They knew what reckless was, kind of, but they didn't know the difference between it and negligence. So
That's bizarre to me. I mean, it's all very. I could talk about juries for quite a while, just about research and how research on what jurors do and do not know. I don't know if any of that exists here.
little bit, yeah. Marla Sandys in Bloomington, IU Bloomington does a lot with, or used to do a lot with jury studies and kind of getting into the ins and outs. But our mens reas in the country are really difficult to discern the differences. So this is a fun case.
Yeah, very cool. And then you'll be doing it in front of kids too, so that's awesome.
Doing it in front of kids, yeah. A couple weeks ago, Mark Lehman from Delphi had the exact same issue in front of the Court of Appeals, and he was at the law school doing a traveling.
Okay.
And so I kind of have an idea of what I'm going to be asked. So different judges, but you know, they're clearly they're clearly considering this issue. So I'm sure they'll publish the decision, and
Yeah.
that
Well,
might be a second bite.
specifically about the instruction.
Yes.
I mean,
He had a different case. I think his client was speeding very, very fast in an area that was too fast for him to be going. And so little different facts, but same issue, exact same issue. Yep.
Right. Okay. Got it. I mean, I err on the side of giving more law than less to the jury.
I always think that too, but
Yeah.
I think the judge in this case was concerned it would confuse them.
Yeah. Well,
Yeah.
you got to kind of know.
Yeah.
Okay. So Delphi, what else are we talking about? So you and I have spoken about this. Everybody's spoken, I'm sure, to everybody else about this, but you put up a tweet the other day that I was like, that makes a lot of sense. Should probably see if she wants to talk about it, about what the appeal process is. Why does it feel like this post-conviction period is taking so long? What's post-conviction relief in an investigation versus the process of direct appeal, and how that looks. And one of the things that your very first paragraph was, basically, I think what everybody's thinking is people are wondering why Rick Allen appeal feels as if it's moving too slow. After all, Rick was sentenced 3 months ago. Is this normal for it to take so long? ? No. But nothing about this case is normal.
Right.
And I think absolutely right.
Yeah, I mean, the trial was longer. We have pretty short trials. You might see a week-long trial in Indiana, and that's considered a pretty long trial. This was 4 weeks, 6 weeks, something like that. It was a long time. And so that's unusual. A lot of pretrial activity. That's unusual. So I knew the transcript was going to be longer. And then, of course, we had, a lot of great work from Michael after the trial in the motion to correct error. That's very unusual in Indiana. We don't usually have those filed because, honestly, nothing comes up after trial a lot of times. And so for him to, there was a lot of surprises at trial. So that took some work. That takes time. So it was just it feels like it's taking forever. But it's not, but it feels like it.
But you bring up the motion to correct error, and I think I get so you make a really good point, is that it doesn't come up often. So I think the honest brokers among us might be able to be forgiven if we think like, oh, what is this weird thing they're throwing at the wall? But the people that should know better should know that this is a tool that's available and needs to be utilized, because that then goes into the appellate record. Is that right?
Yeah. And sometimes motions to correct error, you might feel like, what's this you're throwing at the wall? Not in this case, though. Honestly, these were good claims. We didn't get a hearing, but these are good claims. And you might have one good claim for a motion to correct error. You're not going to have, there were several. And so this needed to be filed. Honestly, there was a lot of discussion about if it wasn't filed, is there a concern that they, the attorneys, once you find this information out, you're really supposed to file on it at your earliest opportunity. You can't really sit back and, keep it in your back pocket. If you've got enough to go forward, you need to file. And so there was a lot of discussion about that, how much more needs to be done in the motion to correct error. Again, I think Michael really did what he could to get as much information that he had learned in that period of time.
Right.
And I shouldn't just say him, trial counsel learned it too, but
Sure.
Yeah.
So just for people in the back who maybe don't pay as close attention, what were the major issues that were in the motion to correct error?
Well, the NAPU claim of the false evidence, to me, that was a pretty strong one. And it's unusual. We don't see those claims a lot in Indiana, and it was also unusual because then we had that SCOTUS decision come down.
The glossip ruling.
Right, right. There was the initial the fact that Rick had counsel, but he had arranged counsel before his initial hearing. That entire issue. I can't remember what else was raised. It's been a while since I looked at it, but those were the two for me that stuck out the most because, that those were, in my opinion, those were pretty big claims. And the NAPU one, especially because we didn't really get a response directly on that claim.
Yeah. I thought that was one of my favorite. I really like to highlight Nick's abomination toward language and all other things in his filings. But that was what I noticed, was that he, in all of his bluster, he didn't address what is very clearly, I think, to your point, the NAPU claim, which, oh, by the way, glossip happened. And oh, by the way, that van Nick that you knew or should have known before you put, what's his name on the stand. So I thought that was very telling. I find it very interesting what the state reveals through McClellan talking or not filing something. So I find it very interesting.
Well, the Reese letters, those didn't come in through the motion to correct error, but they came after. But I think that they'll be in the appellate record because I think that was before the notice of completion of clerk's record was filed. So those will go up too. We had a Reese claim in the motion to correct error, right? If I remember, I can't remember. There's been so much filed. Michael will tell the chat. But there was so much filed. So, and in a way, that's sort of like post-conviction investigation. That's where you've got a couple things that popped up immediately, and you spend your time investigating that. So in a way, some post-conviction investigation has already started. It's just that it hasn't formally started yet. So
well, and one of the things I want to make clear to people too, because there's just such bad, I think that bad coverage overall of what some people would think are boring issues, but there's this idea that some of this evidence wasn't, quote, newly discovered. And it's like, well, okay, but for certain, especially for the NAPU claim, that was immaterial, right? Because it was because that should have been, it should have been, McClellan should have known that was there and not put on that testimony. But when you talk about newly discovered, I mean, things like you said come up at trial. And so it's not like there's lazy, not making excuses for trial counsel or anything like that. It doesn't mean that trial counsel necessarily missed something. I think in this case, it seemed like more things were being revealed as we went along, and some things, I mean, that was my perception of it.
Right. And of course, the NAPU claim, the error is pretty much made when the testimony is presented at that point, and now the jury's heard it. Can you unring that bell at that point? And that's a big part of the problem. Is it's really, trial counsel's not under an obligation to unring the bell and to try to prove him to be a liar, or I shouldn't even say to prove the witness to be a liar, but to show that his testimony was false. But at the same time, as soon as he puts that false testimony up, the jury's heard it now, And so now you're in a situation where how do you unring that bell? You really can't.
That's going to be an interesting one to watch. And that will, so that the NAPU, the Reese letters, all of that now. So when we talk about the appellate process, direct appeal versus post-conviction relief, everything. So when the completion was filed, or when Jody filed her completion and went on like a 4-week vacation, sorry, everybody needs a vacation, but send out the thumb drives.
She does. I think people are upset because they don't have their thumb drives.
Yeah.
Having said that, I'll give her props for the fact that she was there. I mean, she was in court day and night, and they're outside of their county. So
yeah, exactly.
I'm not going to fault her for taking some time off, but the frustration is not with her as much as just with the time. Yeah. It is frustrating. I understand that.
Yeah. And I don't blame her. I would want to get out too.
I want to get out, but it is frustrating for the public. This is this is not normal. This is not what we see in cases. When you ask for an exhibit, you get it. If it's not sealed, you can get access to it.
What about the idea that I mean, once a case, there's nothing in the. I'm just trying to think of a way around how these things would not be public. And it's
I don't think anyone's saying they're not public.
Or I mean, available. I'm sorry.
Yeah, I don't know. I've not seen this, because honestly, now there are more exhibits in this case than usual. So there is some management of those exhibits, but generally that management, goes on as the trial is going on. I mean, most court reporters will have those already, every day they'll kind of line those up. They'll already have the stickers on them.
Right.
So, but again, I understood not releasing them maybe within the first month or two, but I read the judge's order saying the exhibits are ready. We've got them ready to go. Send me your thumb drives. And it sounds like people are still getting, from this point, no, I don't understand why they're not being shared. No.
Yeah. And I mean, and the thing is, again, it's like this problem with being the opacity of the way this entire thing was done. It feeds into, I think, rightfully, the perception that there's something weird. I don't know how you can have observed, unless you're just absolutely being a sanctimonious turd who's not being intellectually honest. I mean, I'm like, really? So much of what has happened throughout the course of this, I mean, the investigation, everything, and now it continues after the trial is over and the man's back in prison. So, it just blows my mind. It blows my mind, but then again, it's Delphi, it's almost, it's
almost like it's expected now.
Right. Which is, and it's like, and the thing is that part of it is like, well, have we been trained? Right. But to not expect, it's almost like an abusive relationship at this point. I mean, it's like, yeah, I don't understand it. And hopefully I did speak to actually a couple of different actual journalists. Sorry. I had to be snarky.
Right.
But that are supposed to be getting them this week. I've not heard any more yet if they have. So we'll see. I mean, hope springs eternal, but yeah, I want to bring up, now we have a demonstrative tonight, everybody. I'm very excited. Very excited. Cara sent this to me and she's like, I don't know if you want to use it or not. I'm like, we're using it. I love it. And I find it very helpful to talk.
Here's kind of where, like, I use this for clients who are new to the criminal justice process to kind of explain it. But the red column, that's kind of the part that Rick is in now. So we've had the trial, which is focused on guilt and innocence. And then all of these steps he can take now after this, they're going to be focused on what happened in the trial court, but errors that occurred, either that the court made or something the state did wrong, maybe evidence shouldn't have come in, evidence should have come in, that kind of thing. It's all going to be looking at whether the conviction, the jury verdicts were valid based on the trial that he received, and that were there errors that would have made a difference in terms of guilt or innocence. So that's kind of the focus of the direct appeal. Where it gets confusing is then at the same time, you've got the next step. Usually you have to go through your direct appeal. And then when your direct appeal's over, you can do post-conviction. You can actually file in court. And what makes this section different, or this proceeding different, is now they assume that the convictions are valid, that everything, that you're guilty. They consider them final. But now you're kind of attacking the fairness of the proceeding that you got. So this is where you're going to see new evidence that comes out, or things your trial attorney did wrong, things your direct appeal attorney did wrong. Those are your main claims there. And what's interesting is after you've gone through these, Court of Appeals, Supreme Court, if you go to SCOTUS, most people don't, but you can after the direct appeal, and then you start back over in the trial court again. And the idea is the judge has sat through the trial, and there's all this stuff she didn't see. She doesn't know what trial counsel looked at and didn't present. She doesn't know what new evidence is out there. So she, having seen the trial and seen the evidence, is the one who would be able to hear new evidence or other evidence in light of everything that she has heard so far, and decide whether or not, the evidence is newly discovered, trial counsel was ineffective, we call it, that kind of thing. And then, once she makes her fact findings, the post-conviction hearing in Indiana looks a lot like a trial, except it's not to a jury, but you can subpoena witnesses, you can do depositions, you get to do an evidentiary hearing. And so it's very, we have very liberal discovery in Indiana. So you can really break the case wide open again if you want.
So that's the point, I think, too, that people are trying to understand why, because one of the things that you said I refer to your notes, that unless post-conviction investigation begins soon, it'll be 5 years from now, probably, because the appellate process, you say, takes X amount of time. How much time would you say direct appeal?
Normally a year from beginning to end, and it could even be shorter. We have a very fast appellate court process in Indiana, but because of the size of his case, the notoriety of it, and then the number of issues, I think it will take longer. Michael estimated 2 years, and he's probably right about that. That's probably good. And in Indiana, you wait to do the post-conviction until the direct appeal is over. And it's not because you want to wait, it's because you have to wait, because most of our clients are indigent, so they get their attorneys for free. And they can't get the state public defender's office to start the post-conviction until the direct appeal is over. So they can't even file and ask for, an attorney to be appointed. The state public defender won't hop on until the direct appeal is over, and they have a wait list. And so the person has to wait through the direct appeal and then get on the wait list and wait through that before that investigation will start. That's in most criminal cases, but Rick's not most criminal cases.
Right. So to be clear, I just want to, so in the appellate process, there's no new information except what's contained in the record.
We call it, you have to stay in the four corners of the record. So it's going to be your court file and everything in the court file, and it's going to be the trial transcript and exhibits. And the Court of Appeals can't go outside of that information, or they shouldn't go outside. They can take judicial notice of, the sky is blue, the grass is green, that kind of stuff, but they can't go outside and go do their own investigation. So everything has to be argued out of that record. So we can't bring anything into the direct appeal and say, hey, I found this new evidence. They will not consider that.
So they have up and through the everything that was filed, including motion to correct error, plus the verified filings from Andy Baldwin, from Reese Davis. All of that is the four corners.
Usually we say it goes up until that notice of completion of clerk's record is filed. When the jurisdiction formally transfers, we'll put in the appendix, which is what goes to the Court of Appeals. We'll put everything up to that point. Yeah. Okay.
Including when Judge Diener scribbled that bizarre order and then jumped out the back window and drove away. including
that one. That will be a fun order for them to read if they haven't already.
yeah. I mean,
Yeah.
I mean, if it weren't so, if it weren't such a desperate situation at the moment, it would be I mean, it still is fascinating, but
Well, it was interesting when the charges were announced. I think we received a copy of that order pretty quickly, or at least lawyers could access it. But we couldn't access anything else about the case, not even the charges. And we were like, what the heck? You've got this bizarre order of the judge saying people are threatening his assistants' lives. And we were like, what is going on? And then we couldn't see what was happening because we had literally nothing.
I mean, if I were to be some sort of grizzled old journalist, I could say that there was a narrative being set. I don't know. I mean, bloodlust and threatening of judicial staff sure does sound scary.
My guess is though Judge Diener's court probably, I mean, they may not even get 4 or 5 phone calls a day, maybe. And then all of a sudden they had media calling constantly.
Yeah.
And they probably didn't know why these things were sealed. I mean, we have what the state said, but when it was unsealed, we were all like, well, that was a nothing burger.
Right.
What was that sealed for?
Right. Well, yeah. He and for whatever reason, he got himself out of there and didn't have anything to do with it anymore. So he really didn't have anything to do with that part of the process. But yeah, so that's going to be a very interesting appellate read. But so then there's one of the things I wanted to ask about is now that's moving forward, right?
Yep.
That's it. That's moving forward right now with Stacey Juliana and I can't remember his
Mark
name.
Lehman, yeah. So
okay.
I'm kind of expecting that the transcript could be done at the end of this month on the due date, just because she's had a lot of time to work on it. And I think a lot of it was transcribed. All the pretrial stuff, I think, was done before the trial. So, if she's been working on it the whole time, she may not need an extension, which, again, that's pretty impressive if she's able to get that done. But so technically so what happens is once the transcript is done, then technically appellate counsel only has 30 days to file their first brief, but they'll get an extension. They'll be able to ask for them. And how many extensions they'll get will just depend on, our Court of Appeals will give you some, but they're not going to give you whatever you want. Their efficiency is very important to them, that they move their cases along. And so we're able to usually get 45 days total if we ask. They might give a bit more for this case because of the size, but it's not going to be 6 months or anything like that.
And then, so once it gets to the point where they, how many, what's the panel of the judicial panel for the appellate?
So in the Court of Appeals, you get a panel of 3. You won't know who the 3 are until either they issue the decision or they set an oral argument.
Okay.
So you just get a random panel of 3 that's picked by a computer. They've got some algorithm. And there are some judges that are quicker than others in writing things, but I imagine whoever takes this case, they've got a lot to go through too. So
there may not even be an oral argument.
They don't have to set one. They only set one, I think, in 3% of their cases.
Wow.
I'll tell you though, I think this is going to get an oral argument. You look at the attorneys, Mark Lehman, Stacey Juliana. They're seasoned attorneys. They do lots of oral arguments, and they do well at the oral arguments. So they're not going to waste the judge's time.
Right.
So I think they'll get an oral argument in both courts, honestly, depending.
I want to ask you what the significance is of the 2 state attorneys that being put on.
There's
their assistant attorney general. Who is it that's been appointed for the state?
So Angela Sanchez I don't remember her exact title. I want to say she's probably the chief of the criminal appeals. Okay. Very seasoned, very experienced. She's not on a lot of appeals that I see. So, but it makes total sense she would be on this. I mean, you're going to put your most experienced. And Ellen Melander, she's very, very experienced. And, you know, I often joke with my husband, when we see her name on something, we feel like we're going to get an oral argument, because usually, you know, she's not going to take these little simple appeals. I think she gets to cherry pick. I'm just guessing,
Really?
but I think she does. And I think
Yeah.
she picks the fun ones to do. Yeah.
Yeah.
So,
Yeah. Okay.
it's interesting they entered so early. And I don't know if that's because they wanted to start reviewing stuff quickly. I'm not sure. I think they knew, obviously they knew it was coming.
Right.
And so they wanted to be, they probably already knew who was going to take it. Yeah.
Yeah. Yeah. Okay. So that, let's just say that's done and dusted, and we have to move on. Let's just say we have to move on then to post conviction.
Yeah.
How does that transition then? Let's just, like, Rick's back in prison. They didn't find it compelling for whatever reason.
Well, at that point, either if the client has money, then he can hire his own lawyer, and he can actually do that at any time he wants to. He could do that right now if he wanted to. If he doesn't have money, then he files his petition. And they have like packets in their facilities. He just fills it out. He tries to fill it out the best he can with raising claims he thinks, you know, he has in his case. And then he files it. And then that will be referred to the state public defender's office. Okay. And they put him on it'll be on a wait list. So you go on the wait list by the order that you file. So they take you in order, first come, first served. And to me, that's a pretty fair way to do it. You know, you're not wanting to go through and try to pick out who has the better claims. You know, I think it's fair to do it the way that they do it. Yeah. But you know, they're only a smaller group of attorneys, and they can only work so fast, and post-conviction takes a while. So they've got a 2-year wait list from the date that you file. And so, you know, he's probably not going to be able to cut that 2-year wait list if he's going through the state public defender. He's just going to have to wait it out.
So I reckon that brings me to the question of, I mean, so I want to jump to, can we just jump to the post conviction? Yeah. But I mean, I want to understand the different avenues, because I think that that's what everybody is. And I do think a lot of it has to do with nothing being available to people to see, nothing, and this being so done in the dark. But certainly because so many people believe him to be factually innocent, you know, and certainly at the very least to not have had his constitutional rights or even some of the Geneva Conventions upheld, frankly. I mean, but so I think there's a sense of like, let's get going on this. What is it that's different about the post conviction that can open up? You had mentioned, you know, you can subpoena and do some other things, right?
What you really do in post conviction, sometimes the passage of time, new things come out. But also, so I will say this at the beginning, you can't skip steps. I mean, you know, somebody like Rick has to go through the direct appeal process, because on post conviction, if a claim is known or available, known and available, on direct appeal, you have to raise it that way. You can't just come straight in on a post conviction. So you have to follow the steps. And like habeas, the federal habeas part, you can't skip through these other steps to go to habeas, you know, the section that Michael does, because the federal courts, they want the state courts to fix their own errors first. Right. And so they make you exhaust your remedies in state court first. So you can't skip steps. That doesn't mean that the steps can't overlap, that you can't be working on 2 of them at the same time. And so when you have a client that has money or that has an attorney who can do this, while the direct appeal is going, it's all its own matter. It is filed all in the appellate courts, has its own case number. It's its own separate thing. And its record is kind of sealed in terms of you can't add anything to it. Post-conviction, totally different. It's not a retrial. But it's basically where it's a different matter completely, has its own cause number as well. It's filed in a different court, and it's a new proceeding. But you're allowed to basically, I tell clients, when you're doing post-conviction, I'm basically I'm relitigating the case. I'm going back through all the discovery, and I'm, doing any investigation. If there's something that wasn't tested, you get it tested. So if you have DNA, let's hypothetically say there's unknown male DNA on a girl who was killed that wasn't tested. You can go test that. If you have hairs that weren't compared, you can go do that. You can do all of that stuff because you've got all the powers of a trial attorney. You can subpoena, depose, do all of that. It's just that, oftentimes clients have to wait because they can't afford their own lawyer. So they have to wait for the state public defender who can do all of that. But if you have the money or the means or an attorney willing to do it, you can start all of that early, and you can be working in the background while the direct appeal's going. And that way you don't have to just sit and wait and twiddle your thumbs and stand down while the appeal's going on. You can be doing stuff because you can do things on the side. You can't do everything. So you don't have subpoena power because there's no proceeding open to you. And you may not be able to force people to give you, to test your, or I should say to get deposed or something. But you can do your own investigation. You can hire experts. You can look at the discovery. You can do all things. Yeah.
So you can so I guess that's part of it too, is getting at the discovery is a huge, because appellate attorneys are not going to do that.
Appellate attorneys aren't going to have it because they have no need to have it. Right. And so they don't need to see more than they need to see. But usually in Indiana, we don't have a problem with this because we all as attorneys have an ethical obligation that we cannot interfere with or disrupt our client's ability to continue to challenge his conviction. And so there's case law. We all understand that when a client asks for a copy of his file, or if a client asks for the discovery that we have, that we've kept for him, because it's his discovery, we have to turn it over to him. We have to provide it to him. We can't say, no, it's going to take me too much time. It's not worth it. There's a continuing ethical obligation for criminal defendants. We have to continue to make sure that if there's something we have that he needs, we've got to, get it to him if it's in our file, especially. So
is that same? I mean, in post-conviction world, the state doesn't have that burden anymore, do they?
They don't, because sometimes if you re-ask for if I were to go to Nick today and ask for the discovery, Nick could say, I already gave it to his attorney. I already gave it to him once. You got to go get it from him. And, sometimes, a lot of times there are prosecutors that won't make you do that. They'll just give it to you. But there are some that won't. And, technically, I mean, that's what some of the case law says is if you've provided it to trial counsel on behalf of the defendant, you can get it from trial counsel. And that's why trial counsel has to give it over to you.
Well, yeah. And I mean, one would like to think in the interest of justice, say, if you came across another person that might look good for a hypothetical double homicide, one would hope that the state would recognize the error of their ways. But alas, this is Delphi.
Right.
But okay, so the question, I think, so that being said, so is there any way, let me step back for 1 second. Is there any possibility that the appellate court is going to say, holy crap, there is not enough here to convict this man, let him free? That's two questions. Do they have the ability to do that? Number one. Number two, what is the likelihood of that in any scenario?
It depends on what's raised. I suppose if they thought that there was not enough evidence that he committed the murders, that's a very high standard to meet, and it rarely works. They could say, nope, this guy is not the one, and reverse his convictions, and he's free to go. The more likely claim is that there was an error made that entitles him to a new trial. And so that, to me, that's probably going to be his strongest remedy would be, hey, I get a new trial at least. It's really hard to say that there's not enough evidence to support the jury's verdict.
Right.
You don't do a lot. Yeah. So they could say that. But of course, if the Court of Appeals says that, whoever wins or loses at the Court of Appeals, they're the intermediate court. And so they're not the final word. Either party can take it on up to the Supreme Court, ask for them to review it. And usually in a case like this, I would expect that whoever the losing party is will do that.
Yeah.
Now, the Supreme Court doesn't have to take it. They can simply say no. But this case has a better than normal chance of them being interested in it. They've already taken 2 actions before.
Yeah.
And it's high profile. So and there are a lot of good issues and a lot
I was going to say
there's some issues
beyond the just it being a high profile case. I mean, it would be a very interesting after Glossop. Right. That's a very interesting thing to bring up. There's also the structural error that could be the not having your retained lawyer at a critical stage, period.
Could be. And especially the Supreme Court loves to decide cases on issues they have not addressed before because, judges just generally like to make law and, they like to fill in law gaps, I guess. They're really looking to try to make the law as clear as possible so that we all practicing can rely on it and know, what we're supposed to do. So, I think he's got a better than normal chance of going on to the Supreme Court. What do I tell my clients though? Even if I think they have an excellent case, the best case I've ever seen, I always tell them I can't guarantee anything. I can't tell you if you're going to win or lose because honestly, I've taken up cases I thought were great cases and lost. And so there's just no predicting. You can have a pretty good idea if you think. Really, I can only kind of predict if I think they might take an oral argument. That's about the best I can predict is, this would probably be a good oral argument case.
Right.
But no, never know when I'm going to win or lose.
Yeah. Yeah. No, I was just curious because I think that's, one of the notions that probably needs to be disabused at this point. That's something that's really on the table that it's probably not on the table. The best, like you said, could hope for is to be retried. But so post-conviction can happen in parallel with the appeal. And so how does that get filed? You said it goes into a different court. What court is that?
It would be, well, I don't want to say Judge Gold's court. It'd be Carroll Circuit 1? It'll be the trial court. You file back into that. But at least while the direct appeal is going, nothing will be filed in a court. This is not unusual. Civil lawyers do this. They'll investigate for a year or 2 before they file something in court. And that's what this essentially is. So there'll just be a lot of work in the background would be what a post-conviction lawyer would do. And especially in a case like this, there's 20, 30 terabytes of discovery. No one can go through that in a week. It's going to take a long time to go through that and to figure out, is there stuff is there new evidence somewhere that we could go out and try to find? Is there, is there testing that could be done? You never know, because a lot of times why people don't do these at the same time is because they think, well, if I'm going to win on appeal, this is all just a waste, right? Except the problem is, no, it's not a waste because I'm fairly certain if he wins, he's still going to be retried. I don't see the state backing down. At least they'll play like they're going to retry. Yes. And those of us that have had exonerations in the past, that's exactly what the prosecutor does. And you'll get an exoneration. You will have proven your client. There's no way your client could do this. And the prosecutor say, well, we're back. We're thinking about retrying. And your client may sit in jail for a little while you try to convince them there's no evidence. So I anticipate he could be retried. And wouldn't you like to have any new information that may have come out?
one would,
at your disposal to now add on to what you already have presented to the trial court, especially the third party guilt. We know trial counsel put forth a crap ton of third party guilt evidence.
Yeah.
What if there's even more out there that we learn, from now until 2 years from now or whatever, that could bolster their defense?
So I think now that Nick has come out and fully embraced the Odinist theory as being this one that the state,
right?
I think now we should figure out how to call him as a witness. Did you, in fact, say this was your theory? Keep talking. I mean, it's like the more people talk, I'm just like, what? It's
well, that's an interesting part too. The number of interviews and I haven't watched a lot of them, but they're especially the police that investigated. You never know what could come out. So
yeah, and I think that there's probably somebody out there doing the Lord's work, listening to a certain podcast.
to listen for this information.
Yes. Oh man. But that is, you want to talk about pre-trial publicity, right? This post-trial publicity is insane.
Yeah.
It's wackyville, and they're too smart by half from what I can see. They're saying weird stuff and they're owning weird things and they're changing it. So it's just, it's going to be interesting. Now, can all of that, and this is seriously, can all of that be brought into any sort of post-conviction case? Like, I insofar as, I mean, if I guess I don't know how, because they are the state and they're out there talking and they're saying things that, what was it? I think McClellan had said something that was kind of new information, or maybe it was something he, in one of his filings. I'm not sure. I don't remember, but can any of that be used at least to potentially make, say this was said on X, Y, and Z date by the lead investigator or whatever?
Here's something I think I remember in a filing from Nick. There was a mention of Reese said Ron Logan changed out the battery on the phone or something. Something about a battery in the phone. Mm-hmm. I wouldn't necessarily try to use Nick's own filing or anything. I would say, okay, well, now that's an interesting fact we've never heard before. Right. Where did that come from? Mm-hmm. And is there evidence to prove that? So if that was something that Reese said at some point somewhere along the line, do we have a copy of that statement? If we don't, why don't we? And also, is it true? Is there evidence that a battery was switched out? I have no idea. That's one thing that I've, that would be what a post-conviction lawyer can do while this direct appeal is going. You can go out there and dig around and see what you can find. Get in the discovery and see, did Reese say this in anything? And if he didn't, how does Nick know this?
Yeah, that's the part, right? Yeah. And so I guess that's the part, because some of the information, and I really do believe, I'm not saying every interview is revelatory, but there's been some things said that are like, what now? Where's that in the, and where's that letter that was tucked inside the Reese letter? So there's just, it feels like there's, maybe a level of malfeasance. I don't.
The letter tucked inside the letter is a good question.
I mean, honestly, there's like all of these. So some of this, I'm mixing some of this up, but all of these, some of their statements that they're making in a public forum to people who are happy to blast it all over the world. I got to believe that some of that, especially with like a battery or whatever, what would be the recourse against, let's say hypothetically that come to find out there was something said, whether it was in an interview or in something, whatever, that a state actor, any state actor, no matter who that would have been, mentioned, yeah, we saw that thing from Keegan Klein and we threw it out. Like, I mean, what's the recourse for something like that egregious? Because there may be things that egregious here.
And Brady, we call them Brady claims, but that is where the prosecutor has withheld evidence that turns out to be material to the defense. Those are also pretty common on post-conviction.
Okay, that's post-conviction.
Yep,
okay.
If you can find them. So there's nothing that direct appeal can do about that, because those would be things that would be outside the record. So that's a post-conviction claim where post-conviction counsel, that's one of the things they can do, is they can try to dig and find, with the Glossop opinion, for example, they didn't know about half of that stuff until the Attorney General turned over that box number 8 full of a treasure trove of stuff. A lot of times that's how Brady claims and NAPU claims and things like that are revealed. It's sheer luck sometimes, or somebody doing the right thing finally. Where
we need to get Kathy Shank back in here. I'm kidding. Get her to find that.
Get her in the filing cabinet. Yes.
To find that piece of information. Sorry, that was me being naughty again.
People, what did she do? She found the statement in a drawer.
Yeah, I mean, it sounds like one of those things where it was like somebody had taped it, and it's not. But in my head, I'm seeing it like, in my head, I see Kathy Shank like vacuuming one day, and she's bending over to vacuum under the desk, and there is a tip that's fallen in the drawer, and Kathy finds it, and oh my God! Now, obviously.
That's not probably how it happened, but what if there is something else that she finds later? The state would have a duty to turn it over, and that can come out like the state could turn it over, and then that's just going to have to be something for post-conviction if his direct appeal is unsuccessful.
How now? Let's say that post-conviction. I mean, Lord knows the crank universe is post-convictioning all over the place, and through rehashing Andrea Burkhart's. I've been going back to listen and hear some of I tried to get her to come on tonight, and she was doing somebody else's show, and I'm like, damn it, that would have been great. So going back through and looking at old things, what will have to, how does that happen in parallel then? So if there is new, like separate counsel, do they work? How do they play with appellate counsel? And is that something that's done often?
They don't have
to. And I mean, do we care? But I mean, honestly.
They don't have to play with appellate counsel at all. They can just be doing their own thing. It would be no different than somebody who, this happens, I'll have a client that committed a criminal offense. Let's say he punched his neighbor or something, and the neighbor makes a homeowner's insurance claim. And so you'll have these civil lawyers doing whatever civil lawyers do over here while the appeal's going. And so there's some relationship between those cases, but they're not the same matters. And so whatever they're doing is what they're doing. And particularly in a direct appeal, because the record it's just, four corners.
Right.
When I've worked with either post-conviction counsel or appellate counsel, depending on which role I was, when I've worked with them, when those two things were going at the same time, every once in a while, they're like, you can ask direct appeal counsel, hey, do you see any places where maybe there was an objection that should have been made and wasn't, or are there any issues you came across you can't raise because they weren't preserved, and there might be that discussion, but really appellate counsel is probably not going to be paying too much attention to the post-conviction case, because there's nothing they can use that information. Yeah. So it's really more of a just checking in. Now, there is a timing issue to this too, though, because once your direct appeal is done, then in Indiana, you're not on a clock to file your PCR petition, but you're on a clock, because in order to use your federal habeas remedy later on down the road, you have to, as soon as the direct appeal is over, and you've gone, there's a certain formula you put in to see when your date starts. The habeas clock starts, and you've got a year to stop that clock or to file the habeas. Okay. And you say, well, wait a minute, we've got this post-conviction we've got to go do. When you file your PCR petition for the post-conviction, that stops the clock. It freezes it. And then
Okay.
you take as
Okay.
long as you like to do your PCR.
Right.
And then when it's done, it starts up again.
Okay.
And so there is some timing that, sometimes there is some talking to direct appeal counsel, like, hey, are you getting close? Are you going to file a petition with the Supreme Court? You ask them some deadline questions just so that post-conviction counsel knows how much time they have to file that PCR petition.
And so there's no downside to starting the post-conviction the post-conviction right now.
No downside. Not to the investigation part, no. To the reviewing discovery and doing investigation on the side, absolutely not. Mm-mm.
And so basically obviously the skill and the experience that lawyers will bring to it, it's about getting access and having that privilege to look at the discovery, or is that, I guess I'm like, what's the hitch and the giddy up to getting at the discovery, right?
Most cases there isn't a hitch, but in this case there was a protective order, and so I think there's some confusion about that. And this is not like the first time I've ever seen a protective order. There's actually a county in Indiana that used to routinely make their trial attorneys sign these like voluntary agreements that they would not share the discovery with anybody, even after the case. And, in my opinion, those agreements are not valid. And, but that they do exist. There have been attorneys that have signed those. But for the most part, it's not a problem. I think what's complicated things is that there is this protective order. And so I think trial counsel has to be careful who they're passing the discovery on to. Or at least I assume that's what their holdup is.
Well, okay. So let me ask you this. So how can there be a protective order? Oh, on the discovery. I'm sorry.
Yes, just on the discovery. Yeah, not on the exhibits. No. And this has been talked about on podcasts. There is absolutely no reason why the public exhibits, anybody can share, like Nick can share those, Holman can share, whoever wants to share those can share those because they are publicly available.
Right.
It's just most of us don't have access to them, so we can't share them. And it seems to be an across the board prohibition, because if the other side, if the podcasters that tend to be pro-state have them, they would have shared them.
Well, that's interesting that you brought that up, because the hidden true crime folks, I think, said something like, well, we have some of the exhibits. And I'm like, what?
They did, and maybe they're not sharing them. Well, it depends on what they have, but maybe they're not sharing them because they're still prepping them or whatever. But again, hey, kudos to them, because there's nothing keeping them from being shared. It's just.
No, I think it's interesting. Yeah. I'm just being kind of snotty now. It's that they have Nick on and then say that they have some of the exhibits. I'm like, you don't say.
Well, I'll be honest, I kind of was surprised the state didn't come out with everything.
Well, again, this goes back to my theory that the Post can, like, everything about this is just weird. I mean, the thing that the silence was straight up deafening after that video came out that was released by the defense, that we know, the silence was deafening, and any conversations that have been happening, and even in that interview, McClellan didn't bat an eye, or, and again, I had to listen to it through a third party because I can't. but I have it on good authority that he didn't discount that's what that really was. So he would have been saying it, he would have been screaming. So
their silence afterwards, and it was just as important as if they had said something that they didn't. I mean, so
I absolutely
didn't surprise me at all. So at least, but here's the great thing: if you're doing post-conviction investigation, then there's no concerns about a protective order or anything, because attorneys, you're representing the client. Technically, all of that discovery belongs to Rick.
Yeah, I was going to say,
Yeah.
yeah,
It's Rick's discovery. So
exactly.
anybody acting on Rick's behalf would be able to access that discovery and be able to review it to help him.
Right.
And really, I worry a lot of this. We've lost sight of the fact that it's Rick who's, this is, I mean, nothing annoys me more than sort of the grifter argument. Oh, you're just, this side is out for clicks and likes. I have like it. That's ridiculous. I haven't received a single penny. In fact, I've had my private messages read out loud, and I've been talked horribly about, called all sorts of names. I haven't received a penny, and yet here I mean, this is literally, it's about Rick, and it keeps people up at night knowing that he's sitting in there, and they really feel he should not be. And
Right.
if you're not going to do something for this guy, what are we all out here doing? Quite frankly,
Right.
This is a
Right.
game. If we're not going to stand up for somebody like him who's rotting,
Exactly.
prison for something that most of us think he didn't do.
Right.
Honestly.
Right.
So, yeah.
Yeah. And I think that the people that say things like that again are, as I said, sanctimonious turds who really are not being intellectually honest. Truly, I mean, truly, you don't have to really be too deep of a puddle to realize that this fundamental, I go back, like, I don't even get past this issue with he had retained counsel.
Right. Right.
And everybody's acting
Yeah.
like, well, so what? He was tortured. Well, what? I'm sorry. It's like,
Right.
okay, Eighth Amendment, and I can go on. But so when people say that's for clicks and whatever, no, it's about transparency. It's about education. It's about, it truly is about just some real basic stuff. And it is, in this particular case, about Rick Allen,
Right. Right.
And it could, I mean, I say it, and I do know that there's a disproportionate impact on communities of color. Obviously, we know that, but this just happens to be one instance of that we're looking at because it was so badly carried out and in such bad faith, and has so many bad actors from my perspective, so many bad actors. But what kind of stuff are like, people are like, what can we do? What can we do? And for me, I will say from my part, and I've talked to you about this before, it's just that, the story is not over. And trying to, it's kind of a gross thing, but it's keeping something in the news is effective. And it's a lot of times, like my example in my line of work in journalism, unfortunately, sometimes you got to hook yourself to a tragedy or a hook. Literally, a hook has to be relevant, to be germane, to be picked up. And the same thing, I've got to believe, happens in your world, where the more people talking about it, the better. I mean, the more people talking about the reality of it, the better.
Definitely. The more people talk about it, I know some people are writing to him, and that's huge. That is the number one complaint clients have, is if I visit with them, it's just lonely. They are lonely in there. And so if you write or something, that always gives them sort of like, they know people haven't forgotten about them.
Mm-hmm.
But also talking about it. And hey, if ever we get another piece of evidence released, I think that there are people out there that do as good a work as some of the investigators I've dealt with, at looking at things, organizing things. If you see something and you're thinking, well, this, if something looks weird, or you've got a take on it, that maybe something, don't hesitate to let somebody know, because people have looked at things and seen things I haven't seen, and various pieces of evidence. And there's never a bad way to have multiple eyes on things. That's always helpful. If you hear something, if you see something in a crazy Reddit or whatever, somebody says something, a theory, we still, even to this day, I still receive emails from people that have you seen this video? Have you read this article? And, I'll look at it as much as I can, time permitting. But yeah, that's like a post-conviction lawyer's dream, is to have somebody sending you stuff to kind of look into, because there's
absolutely,
usually we have the problem of there's nothing more we can, like, everything's been investigated and there's nowhere to go and your client looks pretty guilty. We don't have this situation where there's a million avenues here.
Well, and I want to clear the air on that too, because I got there's nothing wrong with having people helping look through, as long as there's no privilege, or whatever the case may be. But to your point, I don't want to hear. I'll keep it in my experience. In my experience as a journalist, I get wacky stuff. Not as much anymore, because, as you know, I've been trying to get out of this stupid business. but just like a bunch of wacky stuff. But it might look wacky, but there's like little pieces and bits and parts. Now, granted, I don't have attorney-client privilege or whatever, but it's the same thing. I want more information.
Right.
And sometimes it takes a village to put together a story. It takes a graphic designer, a photographer, a cop. And to me, it's like, this is the same thing. So when people talk about cranks and all this other, I got no time for it, because some of the, the best journalists are cranks. So, I mean, there's nothing wrong with that. I mean, right? from this perspective, from a legal perspective. I mean, yes. Cara. Hello?
Oh, well, now you're back.
Okay, sorry.
No,
No. So when, I guess, when you were talking about being outed and being talked about and all these other things, we know what people are talking about, but there's nothing nefarious going on with having people look into information.
No, in fact, some of the best post-conviction lawyers I know in the state are people that they'll go down some crazy rabbit holes to see if there's something there. Because, what would you rather? I mean, what are you going to do? Not go down that rabbit hole and look something up? What if there's something there? And we could probably all think of some high-profile examples where, you've seen somebody kind of look into something that sounded a little bit crazy and turned out, in fact, revealed something pretty helpful. So in my opinion, if you're just going to, on post-conviction, just look at the record and, it looks like it looks, and you're not really going to dig in and try to look and see what else there is, you're really doing your client a disservice. Usually on post-conviction, we have the problem of the client has a ton of investigation they want you to do, and you're really trying to kind of figure out what will be most helpful or what needs to be done, because they don't have, infinite resources.
Right.
But in this case, you've got a pretty quiet client. I don't know how much people are talking to him. So he's pretty quiet right now, but it's just that he's got this community of people around him that see there's so many avenues that need to be investigated, that may or may not have been. We just don't know because of the secrecy around this entire trial.
Yeah.
I mean, everything about the trial. I was explaining something to somebody today about the videos that were shown in court, and the TV was turned around. And, I was kind of like, I don't know if those exhibits are confidential. I don't know what turning the TV away from the gallery but showing it to everybody else means. and then knowing that the gallery could still see it from somebody's laptop. I have no idea what, just the entire secrecy of the whole trial was, and this whole case has just really made things a mess.
Yeah. And I don't know. And so I guess, one of the things is that, obviously in with post-conviction work, okay, so let's say hypothetically that I somehow become an Indiana lawyer overnight, and I take on the post-conviction case. Can I just talk about it till the cows come home? Like, I'm working on this, we're doing this, or is that something? I guess I'm asking because it's like, again, I feel like there's just sort of this, there's within the public sphere, the conversations, if anything, are coming from the state repeating their narrative, whereas some of the other things that we know to be true, even in the motion to correct error, and even from the trial, still aren't making it through. And I know the appellate attorneys aren't going to be speaking in any way, shape, or form. I just wonder if there is a way to bring people along for the post-conviction when that comes.
Yeah, because there's nothing keeping post-conviction lawyers from talking. Obviously, they can't reveal confidential information, but other than that, and they'll want to make sure, you always want to make sure your client is okay with it. So in some cases, it's kind of like a chess game. Sometimes you don't want to show your hand too soon. You don't want the prosecutor to know what you have beforehand, because there are some prosecutors that don't understand post-conviction that well. And so you gain an advantage if you go in there and they think this is just kind of this, sort of quickie little petition that's going to take a couple hours and they'll be on their way. And you can kind of surprise them with, you've got this, a ton of evidence to present. In a case like this, though, I mean, there aren't going to be, no one's going to be surprised that there's an entire group of people wanting to re-investigate this case. There are so many people out there telling me this crime hasn't been solved, and that's the thing, so you're not going to surprise anybody. In my opinion, I don't see any reason why you wouldn't want, to keep people involved who are interested in the case. And it's just so hard to think of examples of cases where shedding light, like shining light on something that's been kept dark for so long, has backfired. You know what I mean? And that's the thing that was so hard at the trial, is that everything was kept so quiet the whole time. And then we had the Franks memo, and people were like, holy crap, there's an entire thing happening we don't know anything about. And it almost seemed like, even after that, things stayed quiet.
Yeah.
And, it's almost like we were looking through at this case, and even at trial, we don't, by God's grace that, Bob and Andrea and people like that were there, we wouldn't even know what happened. And
it's terrifying. It's terrifying to think of that.
Yeah.
I mean, really.
Yeah. I mean, just to not even know it, because there were like just a small group of people that could go in there. And so to me, that's the problem. That's been one big problem with this case that has really hurt both sides, because the state, it hurts them too, because by being so quiet and secretive, we all think they don't have anything. Right. And we think they don't want us to see what they have, because we're going to figure out there's nothing there. You've got the wrong guy, type of thing. So it really hasn't worked in their favor either. And yet it just seems to persist. There's going to come a day where those exhibits are going to get out, because they're going to get filed in the Court of Appeals. That day's coming. But in the meantime, post-conviction, if Rick can get post-conviction investigation going, it's a separate proceeding. There's no reason why, as that investigation's progressing, that his counsel can't talk about, hey, here's what we found. You don't have to worry. You're not infecting a jury pool, because the jury's already, and so there's really not, it's no different than any other post-conviction case. And it's interesting too, there's documentaries, we had a Dateline on this case. There's
Right.
rumors of documentaries.
Ugh.
I mean, it's not
No.
like this isn't going to be up in our face, for several years. And
N-
so,
No. And I think that that's, I look at like I keep thinking of the West Memphis Three for some,
yep.
and how, I mean, I don't know if it's an appropriate analog, but it's pretty close for my, just in my sort of realm of knowledge of these things. Or what's his name, Ryan Ferguson in
Oh,
Missouri, or I mean, I guess there's good examples of sort of bumbled investigations, plus pretty obviously not the right person. But you know, it's just when, so how soon, well, and the thing is, it's like it's such a nebulous concept, the post conviction process, because I'm trying to see here on your diagram, is that, so none of this though can start in your diagram, is that right? Until, I mean, the investigation obviously can, post conviction relief. So you would have to file like a post conviction, like a brief or with new information in it, then when you get to the post conviction phase.
when when you think you're ready to actually do, to litigate, you've got your investigation done, you know what your claims are. That's whenever you want to file your PCR
Okay.
petition. Yep.
Okay. And theoretically, that could happen. Could that happen immediately after whatever ruling at the appellate level? Or does it have to wait to go back to, like, do they want to file it with Supreme Court? Do you have to wait on that?
So that's where you'll want to talk to appellate counsel to see, are you going to file, like, let's say they lose
Okay.
at the Court of Appeals. You would want to ask them, hey, are you going to file with the Supreme Court? If they
Mhm.
say you are, okay, you'll wait. And then the direct appeal is over when the court officially certifies its
Mhm.
decision. That's
Mhm.
just a sort of administrative thing, but it's like, putting a seal of approval, this appeal is over, this conviction's final, whatever. And then that's kind of the green light. You can file your PCR.
Mhm.
Again, in most cases, you don't file it that quickly because that person doesn't even have a lawyer at that point.
Right.
It's unusual to have an attorney be able to get up and running. But in the cases where I've had that happen, it's been because counsel or the client had money and was able to start that process at the same time because he didn't want to wait through, the appeal and into the post-conviction investigation. He didn't want to wait that long. He wanted to
Yeah.
file quickly.
Mhm.
And then you leave that federal habeas lawyer as much time as possible because you stop the clock quickly. And so
Mhm.
he's got the rest of that year left on that clock to be able to prepare his own habeas petition. And it's not unusual either. Michael probably knows more about this, but it's not unusual for a client to want to even start the habeas petition while the post-conviction, and I mean,
Okay.
start it as in start working on it.
Right.
And sometimes clients that ask me about that, hey, what can I be working on during the direct appeal, or what can I work on during the PCR? I'll say, hey, start doing research and put a petition together. Start working on it. Figure out what it is you want to file in court. That way, you're ready to go once you're able to file.
I wish we knew a good habeas attorney.
Yeah.
um, I want to ask, okay, so this is out of left field. And I always think okay, this is just the way my brain works. I always think of it as a Heimlich maneuver, but it's the Dayton, it's the Hatton.
Oh, Davis Hatton. Yes.
I don't know
I was
why.
like, Heimlich.
I
I didn't
know
know.
it's not, but it's a maneuver. I don't know. So can you tell me what that is and if that's an option anymore?
Yeah. So on our chart here, if you go to the red column, go down to Court of Appeals.
Uh-huh.
So after the trial, so usually it happens, you're in the Court of Appeals in that red box,
Mm-hmm.
and the appellate attorney's reviewing stuff, and they're like, oh crap, there's a huge issue that happened. I can see it. I bet if I go investigate this, this may be a game changer, or might entitle my client to a new trial type of thing. And I don't want to even, I've looked at the appellate issues, they're not that good, or this issue is just so clear cut, I'm going to go do it. And what you do is you file a notice or a motion in the Court of Appeals, and you ask them, hey, I want to stop and stay right here in this red box and don't do anything more. I want to go back to the trial court and do my PCR petition. I want to do that middle part. You hang tight. Let me go do that. And when I'm done, I'll come up and I'll join the two together. So my two Court of Appeals boxes there, the red and the green or whatever, they're gonna join together, and I'm gonna do it all at the same time. And so I'll appeal not just my original issues, but I'm gonna appeal the ones where I lost on post-conviction too. It's rare because it requires the appellate attorney to do it.
Okay.
It's a lot of work.
And what's it actually called? Not Heimlich, but
Davis Hatton. So it's named after two cases, Davis and Hatton. So we call it a Davis Hatton. I think Michael calls it a Davis petition. That's kind of the old school term for it. And there just was a case in the Court of Appeals maybe a week or two ago where somebody had done a Davis Hatton. And so it was, but it's usually, I've done it before when I've seen something that was so glaring. Like I had a client who pleaded guilty and had no attorney. Like he pleaded at his initial hearing and kind of made a side deal with the prosecutor. He wasn't really advised properly, and he had nothing on his appeal really. So I talked to him and I was like, let's stop your appeal. Go do a post-conviction on that and come back up. And I ended up doing that. And I can't remember what happened, but that's sort of how it comes in. It's rare because, sometimes it can prolong things. If it's a case where
I see.
Because post-conviction takes so much longer a lot of times than the appeal, because if you stop it and you go do a Davis Hatton, as now you're on the hook, you've got to do the whole post-conviction.
Oh,
you can't leave anything out. If you leave something out, you've burned your client's chance to do it.
Okay.
So it's a lot more pressure, but there are circumstances where it is it's advantageous.
So this is a question. If y'all have questions, just put a question mark, like Nicole did here, because that's the way I see them. The difference between the issues being raised at each level. So direct appeal, we kind of talked about that, the four corners of the trial, everything filed up and through the motion to correct error, everything, and being raised at each level, direct appeal versus post-conviction versus habeas.
Yes. Your most common direct appeal, the judge improperly allowed evidence in. There wasn't sufficient evidence to support the jury's verdict. My sentence was too long. Those are the kinds of issues that we often see in direct appeal. The police violated my Fourth Amendment right, and that evidence should have been suppressed, that sort of stuff. Post-conviction, you're going to see ineffective assistance of trial counsel. That means your trial counsel messed up in some way, and the mistake was huge. It was enough that you probably, there's a reasonable probability you would have been acquitted at trial, or you would have gotten a better result or something. And you can do that for both trial counsel and direct appeal counsel. And then other issues, Brady claims, newly discovered evidence, NAPU claims, those are going to be your big ones.
And that's in
the green part, the post-conviction. Federal habeas, Michael will correct me if I'm wrong in the chat, but if I understand right, it's only going to be your federal constitutional claims.
There he is, like a habeas corpus.
Oh, and he probably means this on a Davis Hatton. That's your other problem. If you can't allege yourself ineffective, and so if you go do a Davis Hatton, you can't check your own ineffectiveness later. You burned that claim for your client. Okay. And again, you explain all this to your client. You let the client decide on that, and but in federal habeas, it's federal constitutional claims. And generally, if I understand right, they have to be they're looking more at, did the state court decide a claim on its merits? And if so, did they really royally screw it up? Did they just completely misapply the law in some way? That's kind of my understanding of the big habeas claim that you're looking at. There's other ways you can, like, if they don't decide a claim, you know, I suppose it would be available, like if you raised it and they just ignored it, type of thing. But there's those are the ones that I see, I think. And again, Michael would be the expert on that. Habeas, I know just enough to know I know what the client has to do to get there. I can't tell you what to do once you're there.
Right.
And so I know just enough to be dangerous. But so that's kind of what I understand. But those are the different kinds of claims that you'll sort of see in each of these. And, you know, you can really complicate the process because you can sometimes go back and try to get a second post-conviction in very limited circumstances. But for the most part, you only get one direct appeal, one post-conviction, and one habeas.
Got it.
So a lot of times, like if you see Stephen Avery or some of these people who have been litigating for years and years, a lot of that is they're trying to go back in and get second and third bites at the apple because they found new information. And I sort of explain it like a pyramid, from the bottom being trial to the top being, I don't know, habeas. Every time you move up that pyramid, your chances of success get smaller and smaller, because what you can do and what you can raise gets smaller and smaller. So that's why it's, you know, it's tough. Your direct appeal, I always tell clients, your trial is the best chance.
Yeah.
Second best chance, direct appeal. Everything after that, you know, you're really you're trying to bring up whatever you can at that point to show you're innocent.
They do, but this does feel different. This case feels, I mean, listen, in if you're not in the upside down, it feels much different. But because it's Delphi, it feels like there's so much that was, and maybe it's, I think it's the general consensus that, you know, he wasn't really allowed to put on a defense.
Right.
You know, there was a lot of potential structural issues. It just feels like there's potential here.
Right.
Would you say that's real?
Yeah, there's a lot of potential. And, you know, the jury was at a disadvantage in that they didn't know that there were all of these alternative suspects and all of this evidence out there that tended to support somebody else doing it. And I think the juror who was interviewed actually said that, you know, something about if somebody else, you know, there was just no evidence that it was anybody else but him, type of thing. Yeah, because you weren't allowed to see it, you know, and that's the hard part. And so those of us, the cranks out here who were able to watch it, right, and we knew what had been filed, and we knew some of the other stuff, you know, that's when we looked at the case, I feel like, so much differently. You know, you saw the strength of the state's case based on the strength. We knew what the defense could have presented if they'd been allowed to. You know, and on post-conviction, obviously the you'd be looking to see what else could have been presented. Is there other stuff? Is there new stuff? You know, that sort of thing.
What didn't they turn over? I'm just waiting. I mean, you know, I'm waiting for that. I'm waiting for the somebody to get at the bottom of Nick's, you know, dustbin and see where some of this stuff might be. I don't know, just a gut feeling based on some of the, because I think that actually that was one of the things that was brought up, that he had mentioned a few things that weren't then clarified in the Reese Davis. So I mean, I think, you know, he mentioned he wants to run for judge, and I think he's going to want to try to do it before this comes back around. I don't know. I got a feeling.
That it's interesting because that's sort of the normal progress you make after you're a prosecutor. You often will go on to be a judge. That tends to be a natural progression. But yeah, and that's the other thing. It would be interesting if he does get a retrial. Will there be a new prosecutor who looks at this case? Will that person look at it the same? That's happened before too. Yeah.
Yeah, and so that's I guess too. I mean, obviously, this would go before Gull again.
It could, yeah. She could decide I'm not messing with this again. She could decide not to be the special judge again. There is a new judge in that court, but I think he worked for the prosecutor's office, so I would assume he would have to recuse himself because he would have worked on this case. So I would assume there would be a special judge again if he got a second chance, and it could be Gull, it could be somebody else. Yeah. Again, though, if he gets a new trial, my guess is it's going to be on the third party guilt issue. And so she's going, even if it's Judge Gull, she'll have instructions from the Court of Appeals. Oh, you've got to allow this in.
Oh, and that's true.
It's a new ball game as to what would happen. You've got a new jury hearing both sides of the story.
Yeah.
Yeah.
I just struggle at. I just struggle with the whole process and the position, the way that this whole thing was positioned, and the sort of apparent lockstep that and I know that this is often the case, but it seems so obvious that Nick and McClellan and the judge, to me, seem to be very simpatico. And the defense didn't have any of that, at all, and seemed to lose favor as the days drug on. But so I don't know. I just.
The thing is, though, that's the thing. Everybody's hopeful that the direct appeal works out well for him, but we don't deal in hope. We deal we prepare for contingencies. Yeah. And so that's the thing, I'm very hopeful. I feel confident, I guess I could say, that his direct appeal is going to turn out well. Yeah. But I can't guarantee it. And so if I'm him, if I were his lawyer, if I talked to him one day, I would say to him, hey, your direct appeal looks good, but you've got great attorneys working on it. Everything's going well, but you've got to prepare for the fact that if you don't win, if you have the ability to be able to start to shortcut this process and be able to start working on your post-conviction now, you should. Right. There's no reason to wait, especially if you've got the means to be able to do it.
Sorry.
I was just going to say, so, to me, I would be trying to prepare for contingencies because it's possible he could lose. And then if we're all kind of kicking back, feeling good, thinking this is going to be a retrial, and he loses, and I've had that happen to me before. I felt that. I know what that's like. Mm-hmm. And so if that happens, then now he's staring down the barrel of 2-3 years of post-conviction when he could be shortcutting that process now.
Yeah.
That's just my thought on that.
Yeah. Yeah. I mean, and what's the, I can't remember what, did Ryan Ferguson, who had the most recent Innocence Project, like the National Innocence Project work? I'm trying to think of the most recent high profile case.
I'm trying to remember if Adnan Syed, he was from the podcast Serial. I can't remember if he was a National Innocence Project or not.
Because I'm just wondering about that kind of stuff with the DNA and everything that wasn't tested, or supposedly wasn't tested, or the hair and stuff, about possibly making something like that happen.
I was thinking of something even simpler. When the Bridge Guy video came out, somebody had taken a still photo from it that had Abby in the foreground and Bridge Guy in the background. They put it in a couple of AI machines and asked, machines, whatever, programs, and asked, hey, how tall are these people? And it was fairly accurate because we know how tall Abby was. We have a good idea of her height, so it was fairly accurate. And the state said, if I remember right, the evidence was that the state was like, we never measured, we never,
Right.
hired somebody to try to predict. Now, I thought the FBI came out and said how tall they thought he was, but I don't know if they were just guessing. I don't know where they got the info. But what if an expert had stepped in and done that, I don't know, after sentencing or before sentencing or something, and said, hey, everybody, I took this picture and I'm an expert in this, and came out and said he was, I don't know, 6 feet tall or whatever, and it clearly couldn't have been Rick. How would that have changed things, or could that's something that post conviction, that's where that sort of evidence, that's where that investigation is done, that kind of evidence can be presented. Some of that stuff, there could be lots of examples of game changing evidence that hasn't been tested or hasn't been looked at, or maybe wasn't even known about.
Right.
Could come out. Yeah.
Right.
And again, the reason clients don't often do these two processes at the same time is because they can't. They don't have the money to. But for the clients that do, I mean, I listed a group of those high-profile cases that did do them at the same time.
Right.
Had them going because they had the means to do it. So,
there's no the post conviction is much like an appellate process, or it goes back to the county. Is that what you said? And is it heard by? It's not heard by a jury though.
Nope, only heard by the judge.
And are there any Cecil searches allowed, or is it just straight?
I mean, she could allow a Cecil search again, yeah. But so it's an evidentiary hearing. You get to present, both sides present the cases, although the defendant goes first because it's his petition now, and he has the burden now. That's the other big thing. Okay. But other than that, yeah, you can put on testimony, exhibits. You can put on just anything you can at trial. Yeah.
Yeah. So what's the over under on getting post conviction and getting a hold of the discoveries into somebody's hands?
That's a good question. It depends on if somebody's gonna try to do that. It's hard right now because I think trial counsel is, their part of it is done, and they've got that protective order that they're not sure what they can and can't share. And so I think that they're waiting on attorneys to actually, for Rick to decide, hey, this is a process I'm going to do. And just waiting on the attorneys to step in and do it. Right. I think that's where it is right now. I just think there's a lot of confusion, and
amongst within the sort of community, or between the council and everybody's trying to figure out what they can do, or
I think everybody. I think there's a lot of confusion, and just people have different ideas because this isn't the normal way that things go. And so you've kind of got the old school thinking, and then what makes this case different is that he's not like another defendant who doesn't have the ability to be able to have attorneys come on board. Right. I mean, that's the biggest difference. And again, I've had this happen before where you have clients doing both of these processes at the same time because they have the means to do it. And so, but they're just rare. And so you don't see it a lot. So I think that's what it is. It's a rare situation. And so people assume you shouldn't be doing that. That's not the way to do it, because that's not the way we've always done it.
Mm-hmm. Well, I'm going to say something controversial, but
no, never heard it before.
No, but I feel like calling the trial counsel and just say, hey, what, you know, what's going on? What's going on here? You know, because to me, and this is probably not fair, but now at this point, since all, you know, that they've done their, the state has done their sort of redemption tour or their whatever tour. Now it's like, all right, now you want the people that were out here supporting and being very conscientious about this whole trial. Why aren't you all helping us help you? And including utilizing the press, including, you know, I mean, call me crazy, but defense attorneys, bless your hearts, but let's move with the swiftness, right? I mean,
yeah, we are notoriously old school in some of our, like, trying to get people. I don't know. I see the criminal defense practice changing in the way that we do things, and there's a lot of people that aren't making the change. And so, and I'm not saying that about this trial counsel. Sure. I'm just saying, honestly, I don't know. It's been very quiet. Michael and I, we talk to each other probably every day. And we've got our group of people that we talk to every day that we're working with. But other than that, it's been pretty quiet. Yeah. And it's not quiet from our end. Right. We'd be more than happy to talk. I just think, honestly, it could be a lot of things. It could be they're burnt out on this case. They lived it, breathed it 2 years or whatever. And turn over the discovery to somebody. Make a copy. Exactly. You know, and they may be waiting on somebody to step up and ask for it too, who they feel they can turn it over. And maybe that's the next step. But who would, okay, so here's a question that might be actionable, actually. Is there, and maybe not, is there a way to find out what the protective order is and how would that be removed is that something that is possible? If that's the protective order is actually on the docket. Somebody in out in the community, they've got it. They could easily share it with you because it was filed into the case. But I mean, but now that it's, there seems to be some confusion if it's still valid. Right. And it's interesting because we've seen interviews of defense investigators, or at least one defense investigator I watched, that she feels the same way I do, as if that's part of the reason that she's not able to speak is because of this protective order. Okay. And so I think that's coming from trial counsel. I think they think that it's still in effect and they can't do anything. And so, and that's fine because the people that can help Rick, that he's going to need a lawyer at some point. Yeah, it's got to go. Yeah, that's the next thing that needs to happen. And the protective order doesn't prevent Rick's lawyers from looking at the discovery. So that's kind of where it's at. But why the exhibits aren't out there, why we're not seeing more discussion, I don't know. Yeah, and that's my thing too. It's just like you got to keep it in the sort of zeitgeist here. Plus, there were, it wouldn't have to be anything confidential, obviously, but like the interrogation videos. Oh my God, yeah. I watch those every day on YouTube and various, people post them all the time. And usually the ones they post, the guys, confessing left and right. These are apparently videos. I haven't seen them. Videos of a guy who's like he's fighting the read technique, right? Right. It's not working on him. Yes. And so I'm like, this would be fun to watch. You'd be able to compare, voices. Many of us have never heard Rick speak before. I've never seen him in anything but a picture. So it'd be kind of, I'd be interested in seeing those. There's no reason why those can't be shared. Release the videos. Yeah. I mean, I'm just kind of at that point, but there's a lot of stuff. Yeah, I don't know. I don't even know what came in at trial as exhibits. Quite frankly, I didn't pay that close of attention. But there's quite a bit of stuff
Yeah.
that would just be of general interest.
Yeah. I mean, and it's like and so, yeah. And I mean, hopefully, hopefully Rick's going to make it. I mean,
Right.
frankly, hopefully Rick's going to make it to and I've been very clear. I don't have any idea what went on. I don't have any inside knowledge that any lawyers, anybody that's seen the discovery. So I lean absolutely innocent. But what I will say is that man did not get a fair trial.
Yeah.
Did not get a fair trial. And if he had gotten a fair trial, based on what they've shown us, there's no way I could have convicted him. So that's the only thing I know. So people that want to come out and say that you're pro innocent and you know what, jerks, I'm just, an objective observer, for crying out loud. But
if he had gotten the trial he should have gotten, and there had been like this full blown third party guilt, and they still convicted him, then you're like, well, okay, maybe we are crazy. Maybe we're not seeing, what they're seeing. And that's the thing. It doesn't do the state any service either, because now they're like, do you feel more confident in the verdict? No, you don't. You would feel more confident if it had been a full blown knockdown, drag out trial.
Yep.
And they came back with a guilty. Then you say, well, you laid everything out there for them.
Yeah,
12
exactly.
people didn't see it your way, but not letting them see, the evidence that tended to show someone else did it. I mean, that's really hard to say he had a fair trial.
I mean, it's an adversarial process to be adversarial within the courtroom, and this was not that.
Right.
This is not that, and that can't be. That can't be, and it's just. So that's where I come down on it. And I do, I just think objectively, you have to be a sanctimonious turd to believe that sanctimonious turd t-shirts coming soon.
I don't know. I feel there are people that just tend to lean towards the as soon as somebody's arrested, they feel like they must have done it type of thing.
Sure.
And then there's a lot of people that are kind of in the middle. They're paying attention. And then there's a few of us that are almost always knee jerk. I don't know if this guy did it. Right. But that's the thing. Nobody knew. And then we saw the probable cause affidavit. And we're like, well, that's not a lot. And then it was, secrecy up until the trial. And then it was essentially the trial was the probable cause affidavit, what little they had.
Right.
And the jury just, I mean, there's no way you get a fair trial if you're not allowed to present easily. There was definitely a nexus to these other.
You know what? I can't.
So that's why I'd love to feel confident about the appeal. I feel really good, but I just know there's no guarantee in life. So
I mean, I guess in Indiana, if you have, somebody show up deceased in your property, that's just not going to be a nexus. Or, you have somebody that, I mean, it's just, there's so many possibilities. It was
they at least had probable cause on Ron, because they got a search warrant.
Yeah, they did.
Required probable cause. So
yeah.
But the jury didn't get to hear anything about him.
And see, that's just it. So that's it. There was no adversarial process. It was not fair. It was not fair.
And that's the thing. I can't. And that's the part of the to kind of explain the differences in the process too. That was an error, in my opinion, that the judge made that was reversible.
Yes.
And so that's raising the direct appeal. And because it's such a large error that it affected the validity of the verdict. I mean, because even if, of course, the jury may have found him guilty based on what they saw, but they didn't get to see everything that was relevant. So
not even close.
Yeah.
But yeah. Okay. So everybody, I think I think that's, I mean, I think we've pretty much talked all of this to death, potentially.
Oh, yeah, hopefully everybody kind of understands a little bit more of the differences. And, you know, if there's anything anybody can do to help Rick, we'll definitely, you know, tweet out. Michael's real shy about tweeting. He doesn't like to tweet on, you know, Twitter and share memes and stuff. I'm just kidding. But
Like, wait, I'm like,
yeah,
Michael, who?
I was just kidding. I was just kidding. He never.
I was like, Cara, are you all right?
He never tweets, but one of us will tweet if we need something or whatever, or think there's a way that can be helped. We'll definitely let people know because,
Yeah.
you know, yeah, any like I'm sure if this ever takes off, if he ever gets to move into this post conviction part, it would be great to have help.
Yeah.
Yeah.
I think you have a lot of people that are very interested in helping out, you know. So I think, you know, thanks everybody for being here. I'm gonna let Cara go and I'll just do a little wrap up. Thanks, Cara. I'll talk to you. Okay. Okay. So thanks everybody. Oh, and thank you. Look at that. Yay. Thank you, Stefan Shear. So that was like that was almost like coasting in on nearly almost 2 hours of hardcore nerdcore. So I hope that helped. Cara's amazing, and I just like this morning sent her a text, would you want to do this? She's like, sure. And so there you go. So hopefully that cleared some things up. Yeah. So wait, what is this? Yeah, well, you know what? Got to get to more what do you call it? Got to get to more sharing weird memes. Habeas corpus. Nerdcore, TM, 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 TM. Somebody's got to have that already, right? Yeah. I mean, Grifton attorneys, Lord knows I'm making bank over here, right? Oh my God, Dr. Vonda. Thank you, Dr. Vonda. I'm so glad you made it to a live. I love doing, like, I'm just such a nerd. But this is to me, it's just so critical. Actually, okay, so before I go, I wanted to let you in on a little secret as to what's going on over here. Do you see my little tiny whale? See my little beluga? Ooh, that's my baby. Case law nerd. Yeah, exactly. So that was your kitty for the evening, right, Toot Toot? Okay. You all know where you can find me. Andy at andycopsa.com, or you can give Kevin and Anya a call. I'm sure they'll put you in touch with a former employer of mine. Oh God. You know what? It's been a pleasure. And I think you guys are the best, but you know, I hate you guys the least.